Good morning, everyone. Thank you for sharing your Friday morning with me. Go ahead, grab your coffee, your tea, water. I want to show you the mug I'm using right now. No drama. This is a very appropriate saying because when it comes to estate planning, it helps to lessen the drama involved with friends and family. We'll start with discussing how to plan, and I'll go ahead and share my screen. I hope everyone can see what I'm sharing. So, estate planning, what is that? Go ahead and take a look at this list. Decide your estate plan. Gather your documents. Begin your inventory. Figure out expenses, including debts. Can I do this myself, or do I need to hire a lawyer? And then review and reassess. Revise as needed. This is the list I will be using during the discussion this morning. Also, if there are any questions, I won't have the opportunity to see them during the presentation. The chat box does not appear while I share my screen. So I'm sorry to say we won't have that opportunity because I do prefer an interactive approach to this discussion. However, I'll have my phone with me to watch the time, and I will try to wrap up around 10:45, 10:50, so we can have plenty of time to go through all your questions. If you do have questions, please type them in the chat box, and I will look at them at the end of my presentation. So with this agenda, hold on, something just popped into my head. Just a heads up that you might recognize some of the comments from 2 previous webinars, and that's fine. My goal is to provide you with the information again so you can benefit and learn. Then you'll be able to recall the information and save it in the files in the back of your mind. Some of this might apply to you, some might not, so please take away and learn what can benefit for your situation. All right, let's roll. Now we want to figure out your plan. You need to think about what documents need to be filled out. Some of us have a very simple estate. There's not a lot of money, and the value of your estate might be low. So you need to figure out, what do I need? Do I need to go straight into setting up those wordy documents? Or can I keep it simple with a last will and testament? That document alone is something that we should all have. Your estate should always have some kind of will in place. Next, living will. I spoke on this last week when we were focusing on medical decisions. While you can't state this in ASL, the medical representative will look at your living will to figure out what you want and expect for your medical needs during specific times. Make sure to understand that the living will does not pick someone to make decisions or communicate with the doctor for you. That has to do with power of attorney, number C. The living will is where you list off everything and document everything. The will stand while you are still alive. When you die, the living will be replaced with your last will. Remember that I emphasize the 2 terms living and last. These 2 terms are already a way to help you remember which documents are needed for what. Item C, power of attorneys, decision making. These are a few decisions that fall under this category: financial, medical, and healthcare. For this, you need to choose a person that you trust and has the responsibility to handle all the details needed to work out with the plan in place. Someone that will honor what you want in regards to your financial and your medical decisions. You choose someone who can take over making those decisions for you, because there might be a time when you can't make those decisions for yourself temporarily or permanently. Moving on to the next item, guardianship. Guardianship applies to you if you have children under the age of 18. You always want to be prepared. Who do you trust to take care of your children and raise them in your stead if you were to pass away? The court would then automatically give guardianship to that chosen person or persons. It could be the other parent, the grandparents, a brother, a sister, your own brother or sister. And if you don't want any of those family members listed, then you can choose a close friend or another family and place them on the list for guardianship. In that process, you can also set up a specific trust that will handle all expenses related with raising your children. Next, item E, final arrangements. Your last party. What do you want? What do you envision? What will you do with your body? All these things need to be considered. Number 2, trust. I'll need to decide if I want to go ahead and create a trust or not. I noticed that I am repeating myself, and I apologize for that. Final arrangements I already commented on before, so I apologize for repeating. All of these things go into your planning. What it will look like, what you need to think about, what documents you need, and what needs to be in place. Do you want to keep it simple by just doing the will? And that's fine, that's great. It's a great start. Or would you rather have a more involved and further documents and plans in place? Which is also great too, but set something up. At minimum, set up your will. That should always be a part of your plan. All of these are different kinds of trusts. I'm not going to go through all of them. There's just not enough time. And some of these might not appropriately apply to you. The most common ones are revocable trusts, irrevocable, moving down to special needs, spendthrift, and Totten trust. Those are the most common. All of them are different trusts that are available to everyone. Again, it depends on the value of your estate. Whether it's worth your time, I'll discuss that in the next slide. The first two, revocable and irrevocable. Basically, revocable means that it can be changed at any time. You, as the testator, decide and fill out the documents stating who will be making the decisions and hold on to everything that the trust includes. You can change it at any time if you want to eliminate anything, add property, remove individuals, add on individuals. You can make change after change until the moment you die. Once you die, revocable then becomes irrevocable. Attempts at changing stop and the trust is locked. But you can also create an irrevocable trust. You can start with making a trust that can never adhere to any changes. That is not a common choice, but it is an option. Moving down to the special needs trust. This one is often created by a parent who has an adult child with a disability, in case it is difficult for them to become financially independent. It's created to help manage their everyday living expenses, and the parents will choose to create a special needs trust. This will allow a certain amount of funds to be used to support the adult child with the disability, such as additional disabilities, everyday expenses, rent, food, clothing, transportation, to set up education, traveling, etc. A special needs trust is a very specific to the individual and their needs. Then there is spendthrift trust, which would be the opposite of the special needs trust. This is not always for an adult child who has a disability, but someone who can't manage their finances. This could be an individual that might act as if they have deep pockets and can spend frivolously. For parents in this situation who do not want to pass on a large sum of money, they'll set up a spendthrift trust. A specific amount of money is set up for specific needs only. An example would be using the funds for living expenses, educational purposes, medical care, etc. A spendthrift trust is not given to someone who can use it whenever they want. It's very specific and regimented, and there will always be an individual pulled in to monitor the spending process. Often the person who the trust is for will need to submit a request stating what they need the money for. And whoever is managing their funds, aka the trustee, will evaluate and determine if the request is valid for spending or not. They'll either approve and grant them spending or deny their request. Totten trust. I had to write some notes to myself about this one because I'm not 100% sure. This trust, the Totten trust, is also known as the payable on death account. I would input funds to a bank account or type of special secured account that has a beneficiary listed on the account. So when I die, this account would automatically transfer funds to the beneficiary listed on the account. No other process is needed. It's automatically transferred to that person who has previously been added and labeled as the beneficiary. So, simply put, these are all the potential trusts to look into. As I mentioned last week related to trusts, I want to bring up questions that was asked last week at the end of the webinar. I didn't have enough time to answer then, so I'll go ahead and address it now. Basically, the most common objectives for setting up a trust can be seen here on this slide. First, reduce the estate tax liability. Yes, unfortunately, your death does manifest specific taxes. I guess we can't die for free, but we can try to minimize the cost of taxes. Second, to protect property in your estate. Third, to avoid probate. This is a court process where all the paperwork must go through to come to an agreement with everyone that the fact that, yes, this individual died. This would be the last opportunity to collect what's owed and pay the final expenses before dispersing your estate. By setting everything up through a trust, you end up bypassing the probate process. Last one, the list of trusts that we just saw in the previous slide, you can establish for specific purposes. You can set up a trust to take care of minors up to the age of 18, or you can set up a trust for charity giving. This is where you'd set up funds that are meant for a charity. Often that correlates with an estate valued at millions of dollars or more. In this case, it becomes beneficial to set up a trust. In the absence of a trust, taxes will build up. So you'll need to consider, will you need to set up a trust or not? Is it worth my time or not? You need to consider the value of your estate. My current estate, it doesn't need a trust. I don't own any property, I don't have a bunch of art that's worth millions of dollars. And based on that, it's not fiscally prudent for me to set up a trust. It's not. But for someone who does have an estate worth millions of dollars with a lot of property, high-valued art, might consider it worth to set up a trust for their estate. But for me, it's not worth my time and it's not worth my money. Next, age of the testator. When comparing youth to senior citizen, it does make a difference. Youths are going to ask, what for? For me, I'm still, knock on wood, I just knocked on my desk, I have my whole life still. So to set up a trust now while I'm young, rather than when I'm older, it does make sense to wait. Because right now, I need to start finalizing my plans. Setting up a trust is not a plan. Marital status as a testator. Are you married? If yes, then there are many different ways to bypass probate. Everything is given to my spouse. There's no need to set up a trust because it's automatically processed. The court will automatically recognize that there is a spouse and give it to them right away. They don't have to do additional paperwork or provide proof. It's automatically processed. Most of the time. Now that we've finished discussing the benefits, there is a downside, which is that it is an expensive process. It's much more detailed, much more time-consuming process, and you still need to have a will. The will is added into the trust, and you need to keep in mind that the trust does not deal with specific disbursement. It doesn't. The will handles that portion. So if you have a list of people you want to receive anything, you must document it in the will, not in the trust. The trust will refer back to what's being stated in the will. So you still need to do the will, and that's why it's the best first step in any estate plan. Moving on to the documents. Now, looking at these documents, this is one form of inventory. You do need to gather all of your documents. When I work with individuals on their estate planning, I have a questionnaire that I use relating to all of these documents listing. I ask for your life insurance policy, policy number, beneficiary, the company address, is there a point of contact and reference, and they are all referenced for each of these documents. Annuities are profits received from your stock investments. That's my basic understanding of annuities. I am not a tax person, and I do not have the full knowledge and understanding of items related with stocks. Next, pension or retirement accounts. The questionnaire I give to clients asks for their pension and retirement account information, account number, bank or company it's with, and contact information. Bank account and divorce records. Why would I be asking for that? That's to provide any potential opposition in court. We want to show that it will be referred to in the will and that you were married, or I am no longer married. The divorce date will be referred in the will. The court will need to know anything that changes your status as an individual. Single, married, divorced, widowed, any of these. Birth and adoption certificates. If you have any children, they'll need to know your children's names, birthday, social security number, and or adoption record number. Real estate deeds for the house. If it's your primary home, other house, a condo, apartment, flat, townhouse, any of these, vacation home. If you own a home in another state, which can become a little bit more complicated because you need to refer to the state, that state's estate laws. So you need to make sure that everything is referred to in the will. With real estate deeds, the will does document the plot name and the number. The county uses those numbers to identify things in the county clerk's office. They have specific ways of identifying that particular property or plot of land by using those numbers or letters. It's very important to have these. If you fully own the property, you will have the deed or house deed, and everything is on the document. It's important to place that with the will. It really helps to identify things after your death. Keeps the process smooth. Next, stocks, bonds, and mutual funds. The physical paperwork shows all the references and information that is needed. It shows the particular account and funds belong to you, and that you own it and can decide who it's given to. All of your documents become a part of your estate planning. It's important to keep all of the paperwork. You can get physical or electronic versions. Either work, but it's important that you get your paperwork organized. Now, inventory. I commented on this topic last week and the week before. I won't spend a lot of time on this. Listed are basic ideas of what you could keep in inventory of. It was mentioned last week that you could have a blanket statement to include everything in your will, which is true. You could. But that leaves a lot of room for misinterpretation. The law likes specifics. The more detailed you are, the better. If I simply stated that all my art is included, well, person A could misunderstand what art entails. Then person B disagrees with what person A on the definition of what art is. For example, person A may say anything that is painted, that's art. But person B says paintings and photographs. Person A says no, photographs should not be counted. But person B says no, photographs are art. So when we are specifying our property, we have to take responsibility to identify what we will include in our estate. That specification helps all of us in the long run. My property is clearly identified and clearly shows what is what, so there is no room for doubt. When we're talking about inventory specifics and details are your best friend. The more detailed you are, the better, even if it's just regarding a few things. You really want to make sure there is no gray area when it comes to dispersing your property. It's your property and you decide who gets it. Be specific with what it is and who gets it. The more detailed you are, the better it is for everyone in the long run. Sentimental items. You might not have a lot that's worth in dollar value, but it is highly cherished. So be specific with those items too. Such as items I got from my grandma. If it's not clear enough, make it very detailed. Again, clearly stated lists are your friend. I mentioned last week that I worked with a couple that had amazing ethics with their planning. They decided to take pictures of everything along with an added description. That was the best approach to their inventory. So that's always an option to think about. Now, relating expenses. If you have any debt when you die, it's gone. It's done with. Not always. Your estate is responsible to pay off any leftover debt. It can. If for whatever reason your estate does not have enough funds to cover all of these expenses, you can file for insolvency, meaning the money isn't there. That process pulls in an executor who comes in to proceed with filing. Basically to say, sorry, this individual does not have enough funds to pay off all of their debt. But understand, when it's stated that the individual has died, any debt left over will be processed and need to be paid off. It's paid from the estate and there is no executor. So because it's paid from the estate, it depends on how much you leave behind. And that included the life insurance policy. The life insurance does not pay off the debt because it's specified benefit given to an individual. But your bank account or stocks, if it does not have a beneficiary listed, it can be used to pay off the remaining debt. If you own property, it can be sold and made into cash funds to pay off the debt. That is the responsibility of your executor. Let me check the time. Looks like we're good so far. Moving on to funeral expenses. Funerals and the proceedings are expensive. Burial proceedings are expensive. That can be paid by the estate unless you've already set something up and everything is paid for in advance. Next item. Again, reminding you that I am not a tax rep. I am not the right person to ask tax questions to. But that being said, there are two types: estate taxes and inheritance taxes. To better understand this, look at what your state offers. Some states have both, some states have one or the other, some have none. The state of California does not have either of these. Estate tax is a tax on the transfer of the property after death. Inheritance tax, that's a tax paid by the heirs. That's my simple explanation. If you want more of an in-depth explanation, I'm not the right person to ask. What's listed are expenses to consider regarding after death. What other expenses do you need to consider? There is a filing fee in court for probate. There's always a filing fee. The different expenses can be taken from the estate. The estate is responsible for all of these expenses. If the estate cannot manage the expenses itself, an executor will come in to manage the estate and pay off any costs and debt. Next, you need to think if you can do it yourself or hire a lawyer. There is no law that says you have to hire a lawyer. But you must know and understand your state laws and comply when planning your estate. If you recall from last week, we talked about the elements of a valid will, and those are legal required elements. Mental capacity, age, even now I can't remember my own list, but I did mention it last week. So if needed, take a look at this list. You have to know those elements, and if you are comfortable doing it yourself, understand and can follow it, it's a great benefit for you. Looking at your estate, is it simple and straightforward? Okay, then do it yourself. If there's a longer list to do and a more complicated approach, it might be worth to think about hiring a lawyer to work with you as you go through it and all the paperwork. If you choose to do it yourself, maybe it was to save money, which you will save money, but what if you mess up at any point? You could have just wasted a lot of time and money filling everything out, and then now you have to go back and hire someone anyway to clean up what happened. So maybe it is better to hire a lawyer, and in the end, it will save you money. Hiring a lawyer will verify that all your paperwork is filled in correctly. It makes it valid. The lawyer is responsible to know all the legal requirements and therefore will make sure everything is valid. That includes all of the basics as well. The lawyer can also confirm the solidarity of the estate plan and offer support through the entire process. They'll be able to answer any of your questions. If you don't understand something, the lawyer can explain and clarify for you. And they will definitely eliminate a lot of the bickering and challenges that might occur. The lawyer can come through and choose the right things for the person that are very clear and know exactly what the person wants. They can answer the court's questions if there are any attempts at forced changes to the will, verify if this child is to be removed from the will, or maybe you have forgotten something. The lawyer can help with perfecting the process, answer questions, and support during the estate planning. It's pretty beneficial. The lawyer will know how to establish a trust based on specific needs you may have. So if you choose to do it yourself, DIY, great. That's an awesome experience and a way to challenge yourself to think, plan, and coordinate all the details. However, maybe you're feeling a little conflicted for whatever reason, then maybe it's worth to consider hiring a lawyer. Again, a lawyer is not required. You can do it yourself, and there are many planning templates online that you can look at to review before choosing which one best fits your situation. Your documents must comply with the law. Is it a legal requirement to hire a lawyer? No, but your documents must comply with the law. All right, all my paperwork is finalized and I'm done with my estate planning. I can file it away and let the dust collection start to form, right? Nope. You need to bring that paperwork back out to be reviewed annually. As I'm looking over it, maybe I remembered I sold or bought property. Did I get married? Did I get divorced? Was there a death recently? Any children born or adopted? Or did any significant changes happen in my life this past year? Those are things to think about when you review your documents annually. It doesn't mean that there will be changes, but you need to know what's documented in your files. For example, I worked with a couple that had a beautifully put together estate plan. How it was set up was great, but it was from 20 years ago. Many things have changed during those 20 years, but the couple didn't take time to look over their documents and update it as needed. So I asked the couple if they minded to have a sit down with me and we'd review everything. They were happy to, so the three of us met up to discuss and review and found out there were a few things that needed, in fact, to be changed. And they were fine with. For those changes, there were some choices on how to go about it. There is an amendment to change only a section of the document or to change the entire document entirely. But it's important to review and assess. Ask yourself, do I need to change anything? And accurately revise. Because revision is not always necessary, currently it may be documented correctly, and you can file it away until you check the following year. This list of people, let me grab my Post-it. Every Friday morning, my brain decides not to work. So people tend to say, I don't need to set up my estate plan. I don't need it. I'm fine. I'll do it later. People like those listed on this slide. Maybe you recognize some of their names. Terry Schiavo from Florida had a heart attack at the age of 25 in 1990. She was placed in a coma from 1990 to 2005. Terry's parents and her husband were in a disagreement and ended up going to court because there was no paperwork to follow. Really, she was 25. There didn't seem to be a need. But the parents and the husband fought about her health decisions. Terry was in a coma and couldn't make any decisions for herself. And really, it should be the husband. But the parents complained and filed for court. It was an ugly, long, drawn-out process. It got to the point where the governor of Florida got involved. The governor, Jeb Bush, his involvement was deemed necessary. He pulled in Florida's government system into the process. It was really a very ugly situation. The only reason it ended was because Terry died in 2005. Next, Heath Ledger, who was an actor. He did have a will set up and all the corresponding documents. But what did he not do? Review and revise. His daughter was not included in the will. What ended up happening was the family said, yes, of course include the daughter in the will, even though it was not actually stated in the will. It's very important when you have a big life change to make sure and go back and change the documents as needed. For Heath's daughter, the family was very understanding, and of course she was able to be recognized as his daughter. Pablo Picasso, the artist. Nothing. No will, no documents, nothing. But he had a massive estate. Of course, he's a very well-known artist, and he had 6 heirs. Those 6 individuals fought in court for 6 years. Interesting number, 6 heirs in 6 years. They fought for 6 years in court to figure out how to handle and resolve Picasso's estate. Intestate means to die without a will, which applies with this, and it is a legal term. Next, Philip Seymour Hoffman. He had a girlfriend and a few children. He was against setting up a trust, saying that my children will never be trust fund babies, meaning they will not receive and live off a trust. So he said, no, I'll give everything to my girlfriend, and he expected the girlfriend to take care of it and the children. What was the problem with that? Well, Hoffman's girlfriend remarried, and that meant a huge estate tax was taken. Ouch. Tom Clancy, he was a well-known author. He had all the documents in place and everything filled out, but it was not well written. There was a lot of gray area, and they didn't know what he was talking about. It was a very complex estate. It was not clear. Things were not specified or described clearly. So it caused a lot of confusion and fighting and frustration with the family. A lot of family drama. It goes with my mug. No drama. So, if your estate plan is not there, it's not clear, there might be a lot of problems that are experienced. So have the documents in place. Have everything clearly laid out and specified to help with eliminating a lot of the drama. And really, to make it a smooth process for your family. So to wrap up, it's 10:50 now. As a reminder, even if you feel healthy, feel young, still, at minimum, do your will. At minimum. You can hold off on getting involved with all the other documents, all the processes, but at minimum, do your own will. When your family has a major change, please review your documents and update those plans and documents accordingly. Have final documents in place for your family to use as a guide. What you envision, communicate that with your family and tell them to please follow your wishes. If your estate as a whole is high value or it's complicated, then it might be worth to think about hiring a lawyer to make sure that you are protected, your estate is protected, or any heirs involved are also protected. It will help making sure everything is protected, and it really helps achieve your goals. I'll now take this opportunity to stop and look at the chat box and move on to the Q&A portion. Looking at the Q&A, first question, based on the value of your estate, how much will it cost to hire a lawyer to help with coordinating your will and all of that? It varies. There isn't a clean-cut number that I can give you. Lawyers set up their own hourly rate. Some lawyers will charge per hour, others will charge a package rate. Really, it varies. I can't give you a for sure number, and I'm sorry about that. But what you pay will determine the quality of the work you receive. Legal fees are often not considered a basic need. It's not like a house or food, health or medical care, So that's a negative part. Because estate planning is very important, and it's something that everyone should consider. So do think about maybe negotiating with a lawyer to pay the fees, figure out a payment plan. But again, I can't give you an exact number for costs, unfortunately. Sorry. Thank you. Next question. For an executor, should I think about listing someone younger than me or older? For this, I would suggest having an alternate or a backup. I'm thinking of my executors. I have 2 people that are older than me and 3 that are younger than me. But I have a team of 2 set up as the main team, and then there are 3 alternates. Age does not matter. What matters is the person's skill and level of responsibilities. Their knowledge and understanding, organizational skills, and willingness are the most important qualities. If, of my 2 chosen team executors, I were to pick someone that was older than me and they died, that means one of my alternates would be added in, ready to take over the position. For me, those qualifications are more important than age. Hopefully that answers your questions. There is a follow-up question to one of my previous answers. Do I give copies to the alternate? Yes. I personally have included all. I keep the originals, then I choose my executor team of 2 and give them the copies of my documents in a sealed envelope. I tell them to hold on to these documents and not open until I've died. And whoever is the alternate, I will also give them copies. They all have the same documents. They all know who is who are the executors, and who are the alternates. They're aware of each other's positions. It's very clear and open communication all the way. In the envelope, I have what everything is and listed, and where I keep my original documents to find when needed. So communication is key and most important. Everyone gets a copy, and I keep the originals.